Nobody's going to muzzle me. Don't tell me whose case it is.
It's not your case.
It's not my case.
So how you
It's
holding
the people's
prosecutor?
case.
After they don't drag me through the mud and destroy my character with lies.
All the animals have been muzzled.
Including
All
you.
the animals have
Including you.
been muzzled.
Yes.
This is Kenton Chance of Eyewitness News, and I'm outside the Calico Magistrates Court, where the Mesopotamia Magistrates Court sat for about 7 days and tried Government Senator Ashelle Morgan and Karim Nelson, an Assistant Director of Public Prosecution, on charges that Ms. Morgan assaulted Mr. Cornelius John and that Mr. Nelson shot him, thereby wounding him and unlawfully discharged a firearm at him. After the closing of the proceedings, we caught up with some of the parties involved, and here are their comments.
I have many comments. First of all, you recall that I predicted that because of the way the prosecution handled this case from the beginning, they were going to win. They were going to acquit the defendants. I predicted that, and my predictions were not even any near way, because I did not factor in a magistrate who would, to my mind, wrongfully exercise his rights. It is very sad because from the beginning I had mentioned to the prosecutor that the relationship between Karim and Vernon Adams, very close. He should have known from day one, get his summons ready. He should have known to get it ready. Secondly,
Who is Vernon Adams?
Vernon Adams is the third person who was there with the DPP and, well, I shouldn't say the DPP, with Karim Nelson and Ashelle Morgan.
Is alleged to be there.
Well, I have their statements, and the Prime Minister went on the radio and said they were there. So I'm not hiding behind no legal nonsense now. This is a time for truth and justice. They went there, the man was shot, and now we have a total acquittal because of the bungling of the way this man was prosecuted, not because of the evidence. The evidence was not properly presented. My instructions are that Rochelle Franklin could have identified Karim Nelson.
And Rochelle Franklin is the neighbor
And
who
she is
who
the neighbor who
responded.
got there first, and whom he asked if her common law husband was at home. She was never asked to identify the tall man. I don't understand why. The magistrate, to my mind, made some wrong rulings when he decided that the DPP could not, the prosecutor could not ask what type of license was issued to Karim. I've never heard anything like that.
Whether he had a license or whether a firearm was issued.
Yeah, but what kind of license he had, or if he had a license as such. That was not a question that was inadmissible. But the most egregious thing of all, in all my 25 years plus of practicing law, criminal law, I have never had a court refuse to summon a prosecution witness who was told to come to court and refused to come, and give a stupid, spurious reason that the trial lasts 6 days. I have done trials for 4 weeks, criminal trials, 5 weeks. Since when 6 days is a timeline that is too short, too long? That is the most purest thing he did, and I'm saying it was a perverse decision that he made. He set it up so that if he did not have the evidence of Vernon Adams, he could say truthfully, nobody properly identified Karim Nelson as being there.
But to what end would a prosecutor do such a thing?
Do what?
Like what you're alleging?
A prosecutor? I'm saying that the magistrate was wrong not to summon the witness. The magistrate was wrong not to summon the witness.
But prosecutor, we don't mean to be impolite, but the lawyers who are actually in the case ahead, we just... Constable Daniel, good morning.
Nobody's going to muzzle me. Don't tell me whose case it is.
It's not your case.
It's not my case.
So how you
It's
holding
the people's
prosecutor?
case. Well, I didn't ask the press. The press asked me.
Okay,
You're
Constable
going to always be
Daniel,
jealous.
your client,
Who's jealous?
your
You're
client
going to
was
always be
acquitted.
jealous.
All the animals have been muzzled.
Including
All
you.
the animals have
Including you.
been muzzled.
Yes.
The ones who are allowed to speak, spoke, and justice spoke for the entire public.
Can you give us a
Those who want to leak things to make it seem as though the case was not fairly tried, they themselves will answer to that. If not in this life, certainly in the next. The evidence was pellucid and clear. And where it was lacking, that was also evident. The matter is still sub judice in respect of Mrs. Bacchus-Batiste's case, when she will finally have voice. And she's entitled to have her voice there. But some people want to have their cake and eat it too. None of us will be attending that trial. We have absolutely no interest in it.
Senator Morgan, do you have anything to say about the outcome of this case in your experience during the trial?
Not at this moment.
No, thank you.
All right, thank you very much. Yes, Councillor Daniel. Can you give us a brief synopsis of what your submission was and what was the ruling of the court?
In relation to Miss Morgan's case, and I'm sure she is able to speak for herself,
She opted not to at this point.
the fact remains that she was charged in respect of assault against Mr. John. Mr. John made certain allegations that she had a firearm. She is not a licensed firearm holder. She is a lawyer and she is a senator. It is rather easy to make an application before the Firearm Licensing Board for a person of her character and stature to hold a licensed firearm. There is absolutely no reason why Senator Morgan would have to be traipsing about with an unlicensed firearm. It is clear that the allegations, and the court found so, made by Mr. John in respect of her having a firearm and in respect of her threatening him that day were unfounded, false, fabricated, and malicious. And I am happy that the court saw through those vicious lies aimed clearly at slandering Miss Morgan's character when it was her efforts to attempt to prevent any assault on Mrs. John that quite possibly prevented there being a worse outcome.
Councillor Marks, any comments on that?
Well, just to say that I'm happy that it's finally over, and I think that the evidence in the matter spoke for itself, and the lack of evidence also spoke volumes too as well. You see, the focus from the time this matter came before the courts, there's been a lot of politics involved in the matter rather than truth and fact. Persons have lost and understandably so, because they're being misguided by persons with political motives who are looking for some political relevance and using the situation to their advantage. This was always about domestic abuse. And what I hope we learn from this is that the police should respond more quickly when they have reports of domestic abuse. That is the genesis of this matter. That is why these people had to intervene. And that is why a part of me, I'm sorry that it didn't go over, so that all the facts would come out and the other side of the story would come out, and we'd see who was the aggressor that day. But that's how it is, and I would not be representing my client's interests if I don't make sure that he's out of jeopardy at the first available opportunity. But the truth would come out eventually, and I hope that what comes out of this is that the police would respond more quickly to reports of domestic violence, as I said, and I hope this does not deter Senator Morgan from the work that she's doing with women in this country and for assisting the underprivileged.
As a person who covered most of the trial, at least the material witnesses, one of the questions that I kept asking myself was, why was Mr. Nelson even charged in the first place? Do you think that the prosecution of your client was, for want of a better term, malicious?
I would not say that. The charges were laid and the evidence should have been gathered to connect all the dots, and the dots were not connected.
There's a document purportedly signed by your client giving account of what might have transpired there. I don't know if you've seen it.
It looks very familiar to a document I saw on the bar table close to a certain person. But I'm very disappointed, and again, this is politics again. This is people who have been intellectually dishonest because of political motives, and we could understand The persons here who they lost the election, they lost the senatorship. They're trying to get back some relevance. And using this domestic violence to do that is really sad. And it also came out in court that same person represented somebody that Mr. John alleged. Well, I believe he admitted to. He said that she claimed that he run him down with a cutlass, but she was just planting some foolishness like that, and the woman just running on her own. And Ms. Marcus Brown represented that woman, so she knows his violence and
But do you remember all of your clients from 20 years ago?
Sorry?
Do you remember all of your clients from 20 years ago?
No, but I certainly would in a circumstance like this, I believe I would have remembered.
And people would ask, why was that document not part of the case? Can you explain legally to us why that's so? The document that we talk about that you said is similar to the one
because it's not a caution statement. The only way it could be admissible is it's a caution statement. Otherwise than that, it is inadmissible. It is hearsay.
And for those members of the public who speak about law versus truth, do you have any comments?
No. You see, there is a particular method. When somebody is called into the police and they're asked to give a statement, they can give a statement in two capacities. They can give their statement in the regular, ordinary course of the mill. Run of the mill as a witness, or they can be cautioned as a suspect. If you are cautioned as a suspect and you give a statement as a suspect, then that caution statement is admissible in evidence. However, if you just went to give an explanation as a regular witness and you gave a statement because you are not under caution and you have certain constitutional rights, that statement is not automatically admissible. And that is what Mr. Marks is speaking about in relation to intellectual dishonesty. There are those who clearly know the difference, but it has been put out there to make it seem as though there is some miscarriage of justice here. Ultimately, this matter turned on credibility. And the greatest bit of evidence to show how incredulous the evidence of Mr. John was is the tissue of lies that he told in relation to being kicked and stamped to the point where one of these stamps in his stomach caused him to excrete stool. There is no medical evidence to support that. Part of the prosecution's case is the medical report submitted in relation to Tuesday the 13th of April 2021 when he presented to accident and emergency. Despite his vicious and malicious lies, the medical report showed clearly there was no abdominal issue. There was no chest issue. It was, he presented unremarkable in that regard. He was not diagnosed with any stomach or chest issues. He was not treated for any stomach or chest issues. That went squarely to his credibility with the other tissue of lies that he told, which thankfully the magistrate was able to see, to show that in addition to the lies he told in relation to Ms. Morgan, that he was not to be treated as a witness of truth. And it is partly on that basis that justice truly prevailed here today.
Any comments on the conduct?
Just before we move on, and just another comment to the medical evidence as well. That it was clear from what we were seeing with the medical evidence that he was shot from a distance. It could not have been a close range shot, and the bone not shot at the foot, not the type of caliber weapon. So it was absolutely clear as well from the medical evidence that he was shot from quite some distance, which accords with our case that he was attacking them with a cutlass when he was shot. And also the evidence showed there was ample opportunity for persons who came onto the scene to remove the cutlass, and also an open window right there that he could have thrown in. The police never went into the house.
But the doctor said that while he might have been able to walk with it, would be under excruciating pain.
Yes, but he did move around quite a lot because the different witnesses described 3 different positions that he was in. And he didn't have to move. If you look at the pictures, he wouldn't have to move much to just throw that cutlass in the open window that was behind him. And I believe that is what he did.
Okay, Mr. John, because your lawyer is not here and you're not a lawyer yourself, I'm just going to ask you if you want to comment about how you feel about the outcome of the case.
Well, I had expected that. Seeing the type of people, they walk, they hold, the position they hold, and being a man of God, God already told me what would have been the outcome. God said,
Mr. Nelson, do you have any comments about the outcome of the case? Okay, Mr. John. Huh? No, I'm just asking you, do you have any comments?
I don't have no comments to make.
Mm-hmm.
What am I to say now? After they don't drag me through the mud and destroy my character with lies, are you supposed to be pleased?
Yes, Mr. John. You were saying being a man of God. Wait, let's wait for the vehicle to you. Yes.
Being a man of God, following in righteousness, the Holy Spirit already told me. These people, they can get around the court of law with man, but in his presence, they are guilty. He said he will not destroy them at this time. He will leave them to get wealth. But if he destroy them, people will forget what happened. He will leave them. So they will get wealth. After getting wealth, they will not be able to enjoy the wealth. This case is not about me and me alone. It is about the nation. Where God is speaking about injustice in the nation, and he himself is going to deal with it. From the beginning, I said, man can get away with man in the court of law by some way or the other. But with God, when you're guilty, you're guilty. God had the final say. This battle, they might want it, but the victory belongs to Jesus.
Your trial is coming up. Are you looking forward to that?
Yes, I'm looking forward for that.
And are you optimistic that the court will treat you fairly?
It is a possibility that they could follow the pattern. The unrighteous is the unrighteous. The unrighteous might be saying right now, where is your God? Your God didn't come true for you. But this is one battle. The final victory belongs to God.
Have you been given a date for that next trial?
No one tell me anything about it.
All right, thank you very much, Mr. John.
And before you go, I just stand here and hear Mr. Mark said, I could have thrown the cutlass through that window.
Okay, okay, go ahead.
At the time of the incident, it had no window, it had plywood nailed up there. So how come could I throw a cutlass through a window where there was no window, there was just plywood nailed up there at that area? So you can see clearly. They talk and they don't know what they talk.
Mr. John, you did complain of having been kicked and so forth by the taller of the two men. Now, when you went to the hospital, did you make any complaint? Did you file any complaint about?
I told the doctor that I was kicked, stamped. There was frongs in their nose with the stool that I had in my pants. The male attendant at the hospital, he followed me to the washroom to take off the pants. The female attendants bring up pants for me, and a pants to put over and an underpants to put on. I still have them home.
And you said you were given an injection in your stomach?
Yes, and the Wednesday when I went to the hospital, I had no pain at that time. But from the Thursday, my belly and inside began to hurt. And they asked me what. I told them it began to hurt because they was asking me all the time, they say you get kicked and stamped. Do you have any pain? I said no, at the beginning it wasn't. But after it gets stale, it began to hurt. And they themselves give me injection in my belly, say that is for the pain and some is antibiotic for the infection. I am surprised that this medical doctor who say he is a medical doctor come to the court.
But remember though, let's not cause aspersion because the doctor said that he did not attend to you on that day.
Yes.
And the report he prepared was based on the notes that he found there. Okay, so let's be careful where you go there because you have to understand what the situation. The doctor said he prepared the report, but he did not attend to you. And what he prepared the report on was based on the attending physicians.
Okay.
So,
they can put what they want.
But like I said, Mr. John, you're not a lawyer. Your lawyer is not here, and I don't want you to say anything that will put yourself in jeopardy. Thank you very much for speaking.
Thank you very much.
To God be the glory. He had the final say.